This is the bomb in this whole decision.
It sure is.
This is the Supreme Court effectively ruling on almost exactly what happened in Terrebonne.
Yeah, 13 years before it happened. We have breaking news regarding the court challenge issued by the Bloc that challenged the result of the federal election in the riding of Terrebonne. We not only disagree with the ruling, but we feel that it sets a dangerous precedent for any challenges in the future, and that it should be immediately appealed.
Let's take a look. So it's from City News, folks, issued by the Canadian Press, so it is everywhere now. Judge rejects request by Bloc Québécois candidate for new vote in Terrebonne.
Montreal. A Superior Court judge has rejected the Bloc Québécois' request for a new election in the Montreal area riding won by the Liberals in April by a single vote. Natalie Sinclair-Desgagnés, the Bloc candidate, has challenged the result in the Terrebonne riding after a Bloc voter revealed that her special ballot was returned to her because of an error in the address on the envelope provided by Elections Canada. In a ruling today, Justice Eric Dufour says the postal code error does not constitute an irregularity as defined under federal electoral law. Dufour says the human administrative error was committed inadvertently and without any malicious or fraudulent intent and did not impact the integrity of the electoral system. The judge says expanding the definition of election irregularity to include administrative errors would open the door to numerous contestations. Dufour writes that annulling an election in a riding should only occur in the most serious of cases. The Liberals won a minority government in the April general election, with Liberal Tatiana Auguste winning Terrebonne by one ballot.
Okay, so what's going on here? Well, the issue is that the judge heard arguments from both sides and effectively said, you know what, because this wasn't malicious and this was just an administrative error, then it's not going to count as an irregularity. And therefore, if it doesn't count as an irregularity, then the second part can't be true, which is an irregularity that caused the result of an election to be essentially in contestation. There's a bunch of problems with this, and I was actually shocked when I read this. I was literally jaw on the floor.
Well, first of all, we were shocked that it came back so quickly.
Right, because this, these hearings just happened last week. We were expecting this to be 6 to 8 weeks out. So the fact that this ruling came so quickly, I guess, is a good thing because it was returned quickly. I'd rather have this result now than 6 to 8 weeks from now. But there's so many things wrong with it, and we're going to take you through exactly what that is. To do that, we start at the Canada Elections Act. This is the area of the Elections Act that we're focusing on because this is what applies when you're contesting the result of an election.
524.1. Any elector who was eligible to vote in an electoral district and any candidate in an electoral district may, by application to a competent court, contest the election in that electoral district on the grounds that A. Under Section 65, the elected candidate was not eligible to be a candidate, or B. There were irregularities, fraud, or corrupt or illegal practices that affected the result of the election.
So there's a really important part in there that is going to cause this judge a lot of headaches. And it's the part where it actually defines what the irregularity is and the grounds in which you can contest it. It says an irregularity, comma, fraud, or et cetera, et cetera. So an irregularity is over here, so it could be administrative. Fraud is over here. Fraud is malicious. Irregularity doesn't necessarily mean malicious, which is why it's separated here. But in this ruling, the judge grouped them together. He said, well, the irregularity wasn't malicious, so therefore it's fine. Well, wait a minute. You're making actually a very, very important legal distinction here. Because if an irregularity must be fraud in order to actually constitute an irregularity, then you're contradicting what is actually in the Elections Canada Act. So that's a big problem. But it's also a big problem because back in 2012, there was a Supreme Court case that reviewed a court challenge to an election in Etobicoke. And this is the one that I had actually spoken about on our previous video and on the live stream. And essentially what happened is the challenge was to an election that was won by around 26 or 24 votes. And the challenge was that those votes and voters weren't actually vetted properly, in that, you know, maybe they weren't actually valid, but the procedure wasn't executed properly, so you can't be sure whether or not those votes should actually count. And what the court said is, in that case, if we were to reject people's ballots based on an administrative error, then that would disenfranchise voters, and we don't necessarily want to do that. But there's some more important implications, because this was a case that was reviewed at the Supreme Court versus the Terrebonne case that was reviewed at the Superior Court. So let's just take a look at that Supreme Court case quickly. Ladies and gentlemen, here it is. And as you can see, it was dated October, ironically, of 2012. And you can see the parties are listed here. Now, the parties aren't the important factor in this. The arguments and the decision is. This is paragraph 1 of this whole thing. A candidate who lost in a close federal election attempts to set aside the result of that election. We are asked to disqualify the votes of several Canadian citizens based on administrative mistakes, notwithstanding evidence that those citizens were in fact entitled to vote. We decline the invitation to do so. The Canadian Charter of Rights and Freedoms and the Canada Elections Act have the clear and historic purpose of enfranchising Canadian citizens such that they may express their democratic preference, and of protecting the integrity of our electoral process. Following these objectives and the wording of the Act, we reject the candidate's attempt to disenfranchise entitled voters and so undermine public confidence in the electoral process. So what does that mean? So this is essentially, they're saying, you know, we reject the candidate's attempt to overturn the election. That's essentially what that says. But what it also says, and this is the important part, is they're saying the candidate's challenge is arguing that we should throw out votes by Canadian voters just because of an administrative mistake. And it's saying that that's not the goal of the Elections Canada Act. The goal of the Elections Canada Act is to enfranchise voters, to encourage them to vote. So this is in effect an opposite case as to what's going on in Terrebonne. This case in Etobicoke is trying to argue we should remove votes from the result, and that's why a by-election should be held. And the Terrebonne case is saying that we should be adding votes to that result, thereby causing the election result to be in question and requesting a by-election. So keep that in mind. Enfranchise versus disenfranchise.
60. An irregularity constitutes evidence from which it may be inferred that a voter was not entitled to vote because it is a breach of procedure designed to establish the voter's entitlement. As indicated, proof of an irregularity may itself be sufficient to show that an invalid vote was cast, thereby affecting the result of the election.
So this is what the Supreme Court is saying in their decision. So they're saying that an irregularity in a procedure that disenfranchises somebody to be able to vote, basically, you know, if an administrative procedure is preventing somebody from being able to vote, then that would constitute an irregularity. But the judge in the Terrebonne decision is saying, no. He's saying the opposite of that, saying, well, it doesn't matter. An administrative mistake is an administrative mistake. It doesn't matter whether the person was able to vote or not.
It needs to be malicious in order to qualify under this law, which, I mean, if you read the Canada Elections Act, is not correct.
Right. So this effectively contradicts what the Supreme Court said in paragraph 60. We continue.
63. Our approach to contested elections allows a judge to consider evidence that an individual was entitled to vote on election day. It has to be remembered that quote-unquote entitlement is concerned with age, citizenship, and residence. A judge may look at any evidence that is relevant to these criteria. This approach best ensures the accuracy of election results. Some prior jurisprudence in the lower court suggests that this approach introduces uncertainty into election results. 64. When a court decides a contested election case based on alleged, quote, irregularities that affected the result, end quote, it is faced with uncertainty as to the outcome of an election arising from allegations of errors in the administration of the election. A contested election decision, by addressing these alleged errors, is designed to remedy this uncertainty. An approach allowing for an examination of voter entitlement bolsters accuracy and confidence that only entitled persons cast ballots.
So what does all that mean? What this means is that the Supreme Court is saying that administrative mistakes are not just something you can fluff off. They're saying that it's actually really important to consider them when you're looking at this. And the Supreme Court is saying, on a balance of decision, you need to ensure that votes are counted versus not counted when faced with an administrative mistake. So we look at Terrebonne. An Elections Canada employee said, oopsie, I mailed out 40 special ballots with the wrong returning address, preventing them from actually being counted on election day, which is addressed in the paragraph 63. So you have a voter who's entitled to vote, who casts their vote properly, and they're trying to vote, and because of an administrative mistake, we're not able to do so. So note nowhere in here does it talk about malice, does it talk about intent, does it talk about anything, because it's not talking about fraud. That's separate. It's not talking about corruption. That's separate. It's talking about voter irregularity, which is by default going to be non-intent, non-malice, therefore administrative in nature. But the Terrebonne judge is trying to completely conflate those and merge them, contradicting what the Supreme Court actually said.
66. By contrast, if a vote cast by an entitled voter were to be rejected in a contested election application because of an irregularity, the voter would be irreparably disenfranchised. This is especially undesirable when the irregularity is outside of the voter's control and is caused solely by the error of an election official.
This is the bomb in this whole decision.
It sure is.
So what does that say to you?
To me, it says that if the voters done everything correctly, they would be disenfranchised to have their ballot rejected by an error caused by somebody at Elections Canada.
Right. So this is the Supreme Court effectively ruling on almost exactly what happened in Terrebonne.
Yeah, 13 years before it happened.
Right. Because what they were doing is ruling on the opposite scenario. And so they're saying, well, in this case, it's safer to just hold these votes here and include them in the count, and the election's going to stand. And then they go on to literally say, by contrast, if the Terrebonne scenario happened, that's a different story.
So contrasting what just happened in Terrebonne to what happened back in 2012, I think the judge in Terrebonne was incorrect.
Right. Now, it doesn't matter whether you're conservative, Bloc, Liberal, NDP, or otherwise. We have to look at, did the judge apply the law correctly? And based on everything that we've seen, the definition of an irregularity in the Elections Act, and what the Supreme Court actually ruled on in one of the most recent cases on this, they spelled it out clearly. This judge did not apply the law correctly. Now, when was this judge appointed? You're probably asking this. Yes, this is a Liberal appointed judge that was appointed in 2023. So, does that come into effect? Only the judge knows that. But it doesn't really matter. What does matter is the judge completely misapplied the law. The Supreme Court has ruled on this, and they ruled on it 13 years ago. So, if I'm the Bloc, I'm getting my pen out, calling up my lawyer and saying, ladies and gentlemen, it's time to appeal because this is garbage and this has already been ruled on. We need a by-election.
Now we're going to look at paragraph 69. In recognizing that mistakes are inevitable, this court does not condone any relaxation of training and procedures. The Commissioner of Canada Elections appointed by the CEO has an obligation to ensure, as far as reasonably possible, that procedures are followed. Failure to live up to this mandate would shake the public's confidence in the election system as a whole and render it vulnerable to abuse and manipulation. That's a very important point, because if you're saying that you have a voter who followed all the steps correctly and their ballot was rejected because somebody at Elections Canada put their own postal code on the envelope instead of Elections Canada's postal code, and that was the sole reason why that vote was rejected, it disenfranchises not only that single voter, but voters across the whole country.
Well, and here's the big picture. If this ruling is allowed to stand and it's not challenged, and I think the Bloc must challenge it, not just for the reason of, they misapplied the law incorrectly and they stand to, potentially not win that seat back. That's actually the smaller concern here. The larger concern is the implication of precedent. What are we talking about? The 2012 Etobicoke election said, well, the administrative mistakes are recognized, but because the spirit of the act is to enfranchise and not disenfranchise voters, we're going to let that stand. The Terrebonne case does the exact opposite, saying, well, we recognize that administrative mistakes happened, but that doesn't matter that a bunch of votes weren't counted. We're going to let the election results stand. What's the big picture of that? What that means, folks, is that it doesn't matter on one side or the other what administrative mistakes are made. The courts are saying we will never, ever overturn an election. And
that's a problem.
Right. They're saying we will only do so if it can be proved that there is malice or fraud.
Which is wrong because, again, the individual who put his own postal code on the envelopes didn't do that on purpose. It was a mistake. Now, you can argue that they didn't tell the returning officer, which was a bigger mistake, or maybe they were trying to hide their steps. I don't know. But the fact being that it did have an impact on how the elections were run. And it had a big impact on the outcome, because had that one vote from Madame Bassé come back, the Terrebonne election would have gone to a by-election because it would have been tied. And the fact that you're saying, well, it wasn't done out of malice, it was a mistake, it was incompetence, it was whatever, therefore we don't have to do anything about it, I think is wrong, because that lets Elections Canada off the hook.
And that employee, knew they made a mistake, recognized it, and then chose not to do anything about that. So it's not just that one mistake was made, it's that it was recognized and the person didn't bother to correct it and let anybody know.
Our courts need to put our democracy first and foremost, because really in a democratic country, that's like the most sacred thing that you have.
Well, and the fact that they're saying that this is what the ruling is saying, well, mistakes are going to happen, and we're not going to bother with administrative mistakes that impact the results of an election, then what the hell is the point of the election in the first place? Because it's the method in which you carry out the election that guarantees the trust from the public that they're exercising their vote and that our democracy is secure. If you are trying to say that we're not going to hold those accountable that are exercising the procedures that operate our election, then what's the point?
Well, and when you have trust breakdown in this case due to an administrative error at the Elections Canada level, and then you go to the judiciary, and the judiciary is like, well, it wasn't out of malice, so we're not going to do anything about it. That's wrong. I feel that's wrong. When something goes wrong with Elections Canada, the judiciary is supposed to be able to step in and correct that to uphold our election laws.